Shalom and welcome to On the House, the podcast where industry experts and professionals discuss real estate in Israel. I'm your host, Debbie Goldfisher, real estate agent, founder and editor-in-chief of buyitinisrael.com. Join us as we explore market trends, legal and tax issues, purchasing tips, neighborhoods throughout Israel, and much more. All this is On the House, helping you make the right move. Welcome, everybody, and thank you for joining us today for the fourth episode of our second season of On the House, which is dedicated to purchasing new construction in Israel. On this episode, I want to talk about the legal aspects of purchasing new construction. You've chosen the project you want to buy, you've selected the unit you like, you've made sure to understand what you're buying and what the apartment comes with, and now you're ready to move forward. Whenever I get started with a client, I emphasize the need to engage with an attorney to manage the legal aspects of the transaction. When I say an attorney, I mean an Israel-based attorney, and even more so, I mean an attorney who specifically practices real estate law. Sometimes people say their brother, their friends, their neighbors, their cousin will help them. But I cannot stress enough that it is better to hire someone who specializes in these areas and know that you're protected. And of course, when you're coming from a foreign country, it's imperative that your attorney speaks your language, can communicate well in English, and understands the intricacies of purchasing from abroad. Over the years, I've worked with many different lawyers who have represented their clients in the purchase of new construction. Most recently, I had a client from the UK who was looking to make a purchase. Even before we got started, I asked if they had a lawyer that they'd like to work with, or if they wanted me to give them a few names to consider. They told me they had someone by the name of Gil Efrati, an Israeli lawyer based in Jerusalem, that they insisted on working with. To me, that was a new name, and being the curious person that I am, I asked how they came to him and why the strong insistence. The client explained that his mother has an old apartment in Jerusalem that is going through Tama 38, urban renewal, and that this particular lawyer is representing the residents of the building. He went on that the way the legal matters have been handled and the service that the lawyer has been giving are above and beyond his expectations, that he's been so impressed that he decided that this would be the professional that he would hire when the time came. Lo and behold, I've had the privilege of working with Gil Efrati on a deal for this client, and b'shah tova, we hope to close later this week. It's always a pleasure to make new connections and expand my network of outstanding professionals who serve the needs of foreign buyers. But as my client said, Gil is a rockstar attorney that I have now seen firsthand, goes the extra mile, and is totally dedicated to his clients. And that is why I decided to meet Gil in person and introduce him to my audience. Gil specializes in a number of areas, including corporate and insolvency law at the Shimron, Molho, Persky Co law firm, and has a particular expertise in real estate law, including Tama 38 urban renewal projects, representing both tenants and investors in gentrification projects. Gil participates in the major insolvency cases handled by the firm, including that of the infamous Hefzibah Group, a large construction company in Israel that collapsed in 2007. With that, Gil, thank you for joining us and welcome to the show.
Thank you.
Okay, so Gil, somebody is looking to buy a home in Israel. They've looked at various properties and they've decided to purchase in a specific new project. At what stage should they contact a lawyer and why?
They should contact a lawyer before signing any document and before making any commitment to enter into the agreement or to make a payment. It is important for the lawyer to check every document that they are being asked to sign, even if it's only an agreement to purchase after and it's just to save the apartment for a certain period of time in order to reserve the apartment while the negotiation is going on. Sometimes such documents can include obligations that we wouldn't want the client to undertake before having examined the project and the legal terms and advised him or her whether they should enter into the transaction, enter it after having understood all the risks that are entailed in doing so.
Understood. So before anybody signs anything, they must engage with a lawyer. And how important is it that it's a real estate lawyer?
It is important. Like in any legal area, you need an expert that is familiar with the area, knows what has to be checked, knows the risks, and how to protect you against the risks that are entailed in doing the transaction or in that area.
So the buyer has selected a unit in a specific project. His agent has negotiated a price. They've negotiated a payment schedule and even the tech specs. And the next step is to sign the Tofes Harshamah and pay a 20,000 shekel deposit. Could you explain to us what is this Tofes Harshamah, this registration form?
A registration form, as I said, is meant to give the prospective buyer and the seller and the developer some comfort that while during a certain, usually not very long period of time, that the negotiations is going on and the due diligence is being done by the buyer and his advisors, and the apartment that the buyer is interested in is not sold by the developer to another prospective buyer. On the other hand, on the part of the developer, he wants to know that the interest of the buyer is a real interest and a serious interest, and that he puts some money on the table to back up the interest. And that will give the developer an incentive to save the apartment until that process of negotiation and due diligence is completed, and because he risks losing another prospective buyer for that apartment.
Sure. So this is a Tofes that summarizes what the purchase is with the price. What details are included in this agreement?
Usually you have to identify the apartment, the building, of course, the apartment, its directions, the area of the apartment, the price, payment schedule. But it is very, very important to clarify in that document that it is not a memorandum of understanding that sometimes under Israeli law can be seen as a binding agreement.
It's not an agreement.
It's not a binding. It has to be clear that it is not a binding agreement, and that the binding agreement will only follow at the later stage after the completion of the negotiation and the due diligence. Otherwise, you risk finding yourself obligated to an apartment before you really decided to buy it.
I see. So generally, how much time does one have between signing this Tofes Harshamah and closing the deal?
It goes case by case, and it depends on a lot of factors, mostly about the process of marketing that the developer is undergoing. If people are knocking on his doors, he will not give us much time. If it's one of the last apartments or there aren't many other prospective buyers out there, he will be more flexible.
So after the lawyer has seen it and agreed that it's acceptable to sign, perhaps made a couple of changes and they've agreed on it, the client signs it and gives a deposit. And that deposit is refundable or not refundable? How does that work?
That's also a matter for negotiations between the parties on a case-by-case basis. When we represent buyers, we strive to have an agreement that the deposit is refundable. Certainly, in the case where the decision not to buy in the end will come as a result of the due diligence we have done or a disagreement about the terms of the agreement, and not just because the buyer has decided that he wants to buy another apartment elsewhere.
The project next door or something.
Yes.
Understood. Okay. So again, it's really an expression of interest to buy this particular apartment in this particular project at this exact price. And then you go straight from there, straight into the due diligence stage. Explain to us a little bit about that stage. What happens next? You are engaged by your client and you're instructed to represent him. What do you do?
We ask to receive the draft of the agreements and all the relevant documents about the project from the developer's attorney. When it's a new project, and usually a high-rise tower, I mean, it's not a small project of only a few apartments, the developer's attorney will usually have already a set of the documents, the agreement and all its appendices that he will ask the buyer to sign, and we will go over them. It is also very important for us to understand at what stage of development the project is. There is a very big difference between a project who's already under construction, namely after a building permit has been issued on the basis of a valid town plan that gives the rights to construct the project, and between a project that has not yet been granted a building permit or even is not yet under an approved town plan to build it. As the later the stage in the process, the more certainty we have. If the town plan has not yet been approved and it's only in the process, for example, then they can know what the developer would like to build, but we cannot know what the planning committees will allow him to build. And that the big difference could be huge. And even after a town plan has been approved that gives the building rights to build the project and a schematic planning of the project, could be significant differences between the basic planning shown in the town plan and the actual final detailed planning approved within the building permit that will be issued by the municipality. Mm-hmm. Until there is a building permit issued, there could be significant differences. And we advise our clients, it's a general practice, but we make sure that if the contract is entered into before there is a building permit, there must be a right of the buyer to cancel, to back out of the deal if it turns out that there's a significant difference between the plans that were shown to him when he was signed the agreement and the actual plans that can be realized according to the building permit.
Right. So how do we define a significant difference?
This is a question that also comes up routinely in urban renewal projects that we deal with. And because in those projects, you must enter into the project before there's a town plan, because you need the approval of the majority of the apartment owners of the relevant project in order to file the town plan. So there's a big component of uncertainty in those projects. When we represent apartment owners in such projects, we include a provision in the agreement that says that if there's a material change, they will be able to back out of the deal. Also, we both give specific examples, such as a significant change in the area of the apartment and so on. And also, we strive to include a general clause, which says that if there's a change that is significant to such an extent that had the buyer known about it when he was negotiating, he would not have signed, this is the type of change that must allow you to back out.
Makes sense.
Now, it's also important to understand, even after there's a building permit, and you know that there must also be an agreement with either a bank or an insurance company that will provide the bank guarantees or the insurance policy that will guarantee the funds that are paid by the buyer. There's a mechanism in place that was put in place in Israeli law after the Hefzibah case, which our office is dealing with on behalf of the official receiver since 2007.
You're still dealing with it?
Still dealing with it.
Really? Wow.
Yeah. In the initial years, the work concentrated on finding solutions for all the thousands of buyers that bought apartments and were left out in the cold. And in the recent years, it's the winding up and taking care of the claims of debt and so on. So in that case, what happened was that the Hefzibah Group was a group of companies. We have under liquidation more than 26 companies that were part of the group. And they built projects all over the country. And they were supposed to deposit the funds of the buyers in closed, supervised accounts dedicated to the projects. And they failed to do that. They took the money and they moved it around, shifted it between the companies.
And nobody noticed.
Some people noticed, some did not. They misled the banks as well. I mean, they misinformed them about the sales that were made and the payments that were made. And they provided bank guarantees. They had an obligation back then. The law required provision of bank guarantees, but not all people insisted on it. Mm-hmm. And they provided guarantees to those who pushed more and pressured them more. And they did not provide them for all the people who put less pressure on them. And when the companies went into bankruptcy, some of the people who paid good money for their apartments, their funds were not secured. And they had no rights to the apartments because the project during its construction stage is mortgaged to the bank who provides the financing to build the project.
So the buyers had nothing to stand by.
They were in a real problem. And what we did at the earliest stage of the Hefzibah case is come to arrangements with the banks in order to save all those thousands of families. And the general arrangement that was made was that with the help of the Bank of Israel Banks who received money improperly and should have known that there's something improper were required by the Bank of Israel to refund them or return the money to the proper account. And for those monies where no bank was at fault and it was basically the money was lost, we came to arrangements with the financing banks that they will recognize 70% of the money that was lost, and the buyers would have to repay only 30% of their money that was lost. Mm-hmm. And that way, we managed to come to an arrangement, a fair arrangement. It was equal more or less across the board and helped people to stay above the water. Wow. Because of in retrospect, because of the continued rise of the real estate prices in Israel, the buyers were not, most of them were not significantly harmed, but some were more than most. So as a result of that case, which threatened to impact the Israeli economy, because it was so large, the sale law regarding securities that must be provided to buyers was amended. And since that time, the developer has to provide the guarantee after the payment of the consideration is made through a specific arrangement of vouchers, which the financing bank provides at the time that the purchase agreement is signed. And all the consideration for such a new apartment must be paid only through those vouchers. And when a payment is made by the voucher, it's made to the proper closed account of the project. And the payment by the voucher is considered an instruction by the developer to the bank to issue the bank guarantee for that payment to the buyer.
So if, God forbid, the developer goes bankrupt at some point, every payment that's been made is guaranteed by the bank.
Yes.
And this is a mechanism that has been introduced as a result precisely of this case that you're involved in, the Hefzibah Group.
Yes, the voucher, the mechanism of payment by voucher was introduced.
Right.
The securing the money by a bank guarantee was there in place before, sure. But it was not properly...
it wasn't enforced.
It was not properly enforced and supervised. It is so important to understand when you buy a new apartment from a developer that until a rather pretty late stage in the process, if you have made the payments according to the voucher system, the money that you put in is secured. Your rights in the apartment come in at a later stage. Because in order to construct a serious project, as I said, you need a financing from a bank. The developer needs financing, both in order to construct the project and in order to provide the bank guarantees to the buyer. Mm-hmm. The bank, in order to provide the financing, needs a security, which is usually the land of the project, the real estate itself. And the bank gets a first mortgage on the project. And on the basis of that mortgage, he provides the financing to the developer in order to build the project, and the bank guarantees to the buyers that secure their funds. Mm-hmm. Until the completion of the construction and the transfer of the possession of the apartment to the buyer, and until he has completed the payment, the payment of the entire consideration for the apartment, the security he receives is only for the money he paid through the bank guarantees.
So if somebody buys at an early stage or at any point before the end of construction is completed, if, God forbid, the developer goes bankrupt, his money is secured, but he doesn't necessarily get an apartment.
That's right. Now, I want to give some assurance in the sense that it is almost always be economic for the bank to complete the project and give the apartments to the buyers and have them complete the payment of the consideration, than returning the money on the basis of the bank guarantees and to sell the project in whatever stage it is to another developer.
It's not in his interest to do that. You'd rather deal with it and...
It's almost always will be preferable for him to complete the project.
I see.
So even if the developer goes into liquidation, chances are that the apartment will be completed. But, and there's all the but, it will take more time because the legal process will take time, the liquidation court, and there might be obligations that the developer provided that the bank will not honor, such as in the equipment, he will include in the apartment and so on. But most of the chances are that the apartment will be completed and the possession will be granted to the buyer eventually. But as I said, until that stage, the money is secured and you don't really have a right in the apartment. You have a contractual right against the developer to receive the rights in the apartment.
Understood. When you do your diligence, I want to understand, what are you investigating, and are you looking into the financial standing of the developer? Is that something that you investigate?
It's difficult to do that. It's easier when it's a publicly traded company, but there are many developers and even serious developers who are private companies, and we won't have the information to do that. But the fact that there is a bank who agreed to provide financing to the developer gives us some comfort, because the bank will not provide financing and will not agree to provide bank guarantees if he has any concerns that the developer cannot complete the project, if he hasn't received an appraiser's report that projects that the project will be profitable with a sufficient profit margin to deal with increasing or decreasing prices of the apartments. And the agreements, it is always clarified that the bank only works for itself and you cannot rely on what is done. But the fact that the bank has done its due diligence and agreed to provide financing gives us some comfort. And as I said, we always clarify to the buyers that until they actually get some registered right in the apartment, which is not subject to a mortgage by the bank or to some other third-party rights, then what is secured is the money.
Understood. Okay. So aside from the financial aspect of the purchase, which obviously is huge, what else is involved in the due diligence stage?
Although we are attorneys and not architects, we always look at the plans that are attached to the draft agreement. And we'd also like to look at the plan of the building permit to see that they are the same.
Making sure that the client is buying what he thinks he's buying.
That's right. We compare the description of the apartment in the agreement with the plan of the apartment. In the case that you spoke about, we found a discrepancy.
Absolutely.
And we want to make sure that the client understands what it is that he is buying.
The client had decided to buy an apartment that was southwest facing, and when Gil got the instructions and he checked in the local municipality's website, the GIS system, if I'm not mistaken, he found that exact apartment was actually not southwest facing, but northwest facing. And when I called the developer to find out what was going on, it turned out that they had actually misrecorded the directions and there was a mistake on their part. But that's why I was so impressed that Gil had picked up on this, because it's something that I personally wouldn't have found myself. And it gives the client a lot of confidence knowing that his lawyer is double checking every aspect.
We also recommend to the client to engage an architect to check both the planning of the apartment and the building itself, to see if they have any concerns about it or not, and also to check the surrounding area. So in order to know what's out there around the building.
So one second, sorry, you're saying an architect should come and inspect the building itself and the surrounding area. If the building isn't built, obviously they can't.
Yes, they can examine the plans, right, and comment, for example, on the location of the parking places that are offered to the buyer, or on the internal planning of the apartment, and maybe there are some internal changes that the buyer would like to make before the apartment is built, and at that stage it will not cost so much to alter it.
Sure.
In the areas around the building, it is good to know what is being built, what is planned, or what the potential is to be built in the coming years. Of course, it cannot be absolute certainty about the future.
Right.
But if you buy an apartment, a relatively small street, and across from it there's a building, a small building, but there are plans in place to construct a high rise right across the street from you, it's better that you know that before you enter into the agreement rather than finding about it after.
Absolutely. That leads me to two important points. And one is that today, with so much urban renewal taking place around the country, it's important to understand not just what is happening across the road, but what's happening in the whole area, because it might be that there are not necessarily any plans to take place across the street today, but in general, there are city plans that allow for the buildings to be demolished and rebuilt into very high towers. So you have to be aware that there is potential for the whole area to change, and that will take time, and you might be living in a construction zone for a while, and you may, very importantly, lose your view. And this is something that I tell people all the time that are looking for a seafront view. Unless you buy on the first line with absolutely nothing in front but the sea, you're not guaranteed of ever. No one can guarantee you that that view will remain. There is no such thing as a view for eternity because, as we know, anything can come up. And even in an area where there are small, low-rise houses, private villas, you never know in 10, 20, 30 years' time what will be there instead. So yes, a view is worth something and it's beautiful, but it's worth engaging with an architect to understand what the plans are and if there's anything in place that's going to be happening in the near future that you should know about. Okay, so now we're in the due diligence stage. We have understood the financial risks. You've looked into the financial aspects. We've engaged with an architect to understand both the internal building and the external environment. And now you are going through the contract, making sure that the terms are favorable for your client. Generally, how long do the negotiations take? And then what happens at the signing?
Usually the purchase agreements from a developer, a large developer for a new apartment will be long.
How long is long?
40 pages, at least 40 pages without the appendices.
And that's in Hebrew?
And that's in Hebrew.
Mm-hmm.
And we usually, when we go over these documents, we have a lot of comments. The developers, and I understand them, I would do the same in the place of their lawyers, want to maintain flexibility for themselves as much as possible and be in a position where a buyer that is not cooperating will not hold up the project, not for the developer, not for the other apartment purchasers. And sometimes they go too far in that. And we try to mitigate the one-sidedness of the agreement as much as possible. It is not possible to go all the way. And some developers are more flexible than others. It also depends on how badly they want the deal with our particular client. Mm-hmm. So we do our best to make it oriented towards the buyer as much as we can. And after we've done what we can, we sit with our client and explain what we have been able to achieve and what not. So he or she will know what they enter into when they sign the agreement. In order to fully understand the agreement, the best thing would be to translate it to the client's language. Mm-hmm. That is something that will take some expense and time, and that's the best option. We cannot go over the agreement line by line, but we will explain in general contents of the agreement, and then the client will have to decide whether he wants to go to a complete translation or decide to execute the agreement on the basis of the explanations he received. It must be clear that if a client has decided not to translate the agreement, he will not be able to argue after the fact that he did not understand what he was signed. So that's a decision one has to make. When on the date of signing in Israel, of course, it's best that the client will sign the agreement on his own. Usually this is done at the offices of the attorney for the developer. Mm-hmm. And if that is the case, it is also possible at the same time to sign the declaration that has to be filed with the real estate tax authorities within 30 days of the signature about the transaction. This, I'm sure we'll speak in a minute about how undergoing with the process when the client is abroad.
Yes, we'll talk about that in a moment. But before we get to that, I want to just understand, so what happens if we don't reach an agreement? What happens if the client decides not to proceed with the transaction?
Then we inform the developer's attorney that the client has decided not to proceed with the transaction. And if an engagement document was signed and a down payment was made, then it should be returned. If according to the terms that were agreed in that document, it's possible to return it.
Sure. Okay, good. So as you've alluded to, a lot of our listeners are buying from overseas. So how does this work? Does somebody have to be in the country to sign? Can they give you the authorization? How does this work?
It is not necessary to be in the country in order to sign. Of course, it's better to have visited here and looked at the area that you're interested in, so you have the buyer will have a general idea.
I agree. I mean, I have actually sold over the years, a couple of times I've sold to clients who have not come here. And I'll be honest with you, I don't like doing it. It's not like a pair of trousers, as I would say, that you don't like them. You don't have to wear them. This is a huge transaction, an enormous amount of money. And it's something that is worth a trip to come for. But once you've made that decision, you don't have to stay here during the entire negotiation period. You can give the lawyer the authorization to act on your behalf.
Exactly. If you have a lawyer already when you are visiting or before you're buying, and you can provide him with the general power of attorney. And on the basis of that general power of attorney, when an apartment is located and the client decides to buy it, on the basis of that general power of attorney, the attorney can execute the documents on behalf of the buyer. This does not mean that the buyer will not have to sign anything, because there's at least one document that an attorney cannot sign on the basis of the power of attorney, and that's the declaration to the real estate tax authority. That declaration has to be signed by the client personally. It can be signed outside of Israel, either before an Israeli consul or before a notary, which with the addition of what is called an apostille stamp, which is a stamp that is added under a convention that was executed by most of the countries around the world, which deals with certification of public documents. Mm-hmm. Now, if a client has not made the trip to Israel or has made the trip to Israel without having an attorney here to which he can provide a general power of attorney, then the general power of attorney or the specific power of attorney for the transaction can also be signed abroad under the same process before a consul or notary plus apostille stamp.
Right. So it's ideal if somebody's in Israel and they know that they want to make the purchase. It's worth having a meeting with a lawyer. It's also always good to meet the person in person and know who you're working with and sign it, so you don't have to go afterwards to a notary or to the Israeli consulate back in your home country.
Yeah, at least for the execution of the agreement. As I said, for the declaration to the real estate tax authority, you will have to go. You have to go to the consul. But
that will be after signing anyway.
Yes, it has to be done within 30 days.
So you can't sign it before you leave the country if you don't know what you're buying. You can only sign it afterwards. Understood. Exactly. Okay. So once you have the power of attorney, you can literally sign the agreement in his name.
Yes.
Your signature will be on the contract.
Yes, I will sign my name and say it's on the basis of a power of attorney.
Right. Now, we're not going to go into all the payments at this point and transferring money and all that. We're going to have another episode for that. But I want to understand, very often when I bring a buyer to a developer, one of the first questions is, does he have a bank account in Israel? So what is the concern? What is the reason for that?
In recent years, it has become more and more difficult to open trust accounts and operate trust accounts in Israel because of the regulations that have been enacted that require banks to share information with tax authorities, provide information particularly to the American tax authorities under the FATCA rules of the United States and under the anti-laundering laws that have been enacted around the world, including in Israel. Because of the voucher system we spoke about earlier, it's not possible, at least at this time, to make a transfer of funds from a foreign bank directly to the bank account of the developer at the bank that provides financing for the project, at least as far as I know until today. And it will be necessary for the buyer or the attorney or someone on his behalf to go to the bank that is making the transfer, provide him with the voucher, and on that basis, the payment will be made into the proper account. So if the buyer has an account here in Israel, it will be much simpler for him to transfer money from abroad into his own account.
Sure.
It will be easier for the local bank to accept those monies because it comes from the account of the same person to his Israeli account. And from that account, the local bank will not find it difficult to make the payment according to the relevant voucher.
So it's ideal if somebody has a bank account here. If you don't have an account here, that doesn't mean you can't purchase an apartment. There are ways around it, but it's certainly less complicated if one has their own bank account
Correct.
here. Any other issues that you could think of that are specific to purchasing off-plan new construction as opposed to buying Yad Shniya, a pre-owned home?
It's also possible to take advice on the specifications of the apartment. There is a relatively long document that comes with the draft agreement of the specifications, which talks about how many electrical points you have, whether you have electrical blinds on the windows or not, and the types of ceramics you'll have on the floor.
Floor tiles, right.
There's room for negotiations there. It's not something that we as attorneys can typically have the expertise to do.
So we actually had an interior designer come in last week to talk about all these changes, and certainly once we know what we want, then we can try and negotiate. Either the agent or the lawyer can try and negotiate those into the legal agreement.
It's also important to find someone who will make the choices of what you want in the apartment. If you have 4 choices of ceramics, then usually when you are an Israeli-based buyer, you can simply go to the shop and look at it and decide what you want to buy. If you're not here, it's more difficult. You have to find someone that will do that for you.
Once the agreement has been signed and all these choices have been made, are you still in the picture? Until what point are you still, representing the client and involved in this transaction?
We stay in the picture until the rights of ownership are finally registered in the land registry office, which means we're in the picture for several years, because usually it will take at least a year after the building has been completed and the possession of the apartment has been transferred for the rights to be registered. Sometimes it takes even more if the land has to go through a parcelization or division process and registration before the common building can be registered. Then it will take even more time than that. And it's important to understand that specifically in high-rise apartments, the process of registration is that after the completion of the project, the common building has to be registered as a common building in the land registry office. And
it's what we call the Beit Meshutaf.
And only after that stage, the ownership in the specific apartments can be registered in the name of their buyers. And when that process is done, you have exclusive ownership in your apartment and on any other areas that are attached to the apartment, such as a storage area or parking area. All the rest of the areas of the building, such as stairwells, systems, and so on, are common property of all of the buyers. And there have to be a maintenance company that maintains all the common areas and systems.
So as a lawyer, when you say you stay in the picture until this registration takes place, are you actively involved? Or, I want to just understand to what extent, can the client engage with you during that period?
Well, if it's a client from abroad, for example, that will presumably hold the bank guarantees that have been provided that secure the funds, the client, either with our help or with someone else, has to arrange for accepting the possession in the apartment. And usually it has to be, we recommend that an engineer be retained to check if there are any defects in the apartments.
We have an episode on that coming up as well.
Okay, that's very important. That stage of transfer of possession, one of the conditions for that is usually transfer of the bank guarantees to a trustee. The bank guarantees are not returned to the developer yet at the stage of transfer of possession, unless at that stage there's already a registration either of ownership rights or at least a cautionary notice in the name of the buyer in the land registry office, which is not subject to the mortgage of the bank that finances the project or to some other third-party right. And because until the buyer has completed paying the entire consideration, has received possession of his apartment, and some registration in the land registry office that is not subject to any other third-party right, the bank guarantees have to stay either in the buyer's possession or possession of his attorney, or in the possession of a trustee that will hold it and will not return it to the developer and to the bank until that stage that allows under law the return of those bank guarantees. Mm-hmm. So we are there to make sure that the bank guarantees are returned or transferred to a trustee under that all the conditions for that to happen have been fulfilled. And we'll also remain in the picture to see that the final rights of ownership have been properly registered. That doesn't mean that we have to make any active acts, mm-hmm. Except to check from time to time what stage the process in. If there's a problem, then we'll advise our client. They usually were retained to represent in the deal and not to take care of any legal action if it becomes necessary. If that does become necessary, God forbid, then we'll have to come to a separate agreement regarding that.
Okay, that's very clear. But that's very important that when you engage with an attorney, that you understand what his role is and where his involvement ends or continues, for that matter. And finally, Gil, I would like to ask you, where do you live and why?
I've been born and live in Jerusalem. After you're used to the Jerusalem air, it's difficult to live anywhere else. It's a very interesting, complicated city, but yes. I wouldn't live anywhere else. I live in a neighborhood that is undergoing urban renewal process. All around us, we're trying to promote an urban renewal project in the project I'm living in.
So which neighborhood is this?
Makor Chaim.
Makor Chaim. That's near Talpiot.
Yes.
Beautiful. Undergoing major urban renewal. All the time I hear about new projects that are happening there.
Yes, it's going to look, the main road, which is called Pirkan, is going to look like Manhattan when it's done.
Wow. Bezrat Hashem.
There are pros and cons for that, but if you want to leave the green areas around Jerusalem, at least the way they are, or as much as they are, then the only solution is to go up. That's
right. Absolutely. We're talking about that all the time. And finally, Gil, if you were to move to a different part of the country, where would you go and why? I mean, you just told us you wouldn't leave Yerushalayim, but if you were to buy another place, where would you go and why?
Probably the Galilee. Life goes on at a different pace there. It's very green, relatively, and nice places to travel. So that would be my second choice.
Beautiful. Okay, well, thank you so much. Really interesting and helpful. Even though you're Israeli, you speak beautiful English, and your written English is outstanding. I wish I could write as well as you write. And I want to thank you so much for sharing your knowledge, your expertise. We're going to put a mention of your email address, your contact information in the show notes. If anybody would like to reach you, they'll be able to. And as we approach the Chag HaGeula, we're approaching Pesach, I want to take this opportunity to wish all of our listeners a Chag Kasher v'Sameach. This should be the holiday of redemption, the Chag HaGeula, and please God, everybody should come home and we should meet in Yerushalayim, Ir HaKodesh. Chag Sameach.
Chag Sameach, amen.
Thank you for listening to On the House. If you enjoyed this episode, make sure to subscribe and share it with your family and friends. You can also visit buyitinisrael.com, where you can find news, market updates, guidance, and much more on real estate in Israel. That's Buy It in Israel, BUYIT, in Israel.com. If you have a question or a specific topic you'd like us to cover on this podcast, please email us at the address you'll find at the bottom of the show notes. Whether you're thinking about Aliyah, looking for a home or a haven, or wanting to support the Israeli economy, now is the time to buy it in Israel.